What happens if you're involved in a civil lawsuit? You're a defendant in a civil case, and you don't cooperate in discovery and disclosure or the investigation of the lawsuit with the plaintiff who's suing you. What happens to you? And I'm making this video because after I posted the Bill Cosby video, so many people have asked me about that, because it kind of raised this issue. I'm not going to get into the Bill Cosby. I'm going to link the Bill Cosby video. You can watch it as to why he's free, but it kind of raised this issue. So I want to, even though I'm a criminal defense lawyer and I do traffic ticket defense, and I don't routinely go to civil court at all anymore, I wanted to answer this question because so many people were curious about it. So in a civil suit, the plaintiff is the person that's going to sue the defendant, alleging some sort of wrongdoing. It could be a car crash, could be a breach of contract, could be a million and one things. And they file a summons and complaint. In the complaint, they make their allegations. The defendant, in turn, needs to file an answer. An answer, you're denying the allegations in the complaint. If you don't file an answer, then the plaintiff takes a default judgment. Down the road, there'll be what they call an inquest. I'll get into that in a minute. The defendant answers it. It basically makes denials. They deny everything. It's just what you do. But let's just say you're a party to a contract, and you know you really kind of did it. You really did breach the contract. It did cause your business partner or whoever damages, and you're just like, I really am not going to play this game. I'm not going to cooperate in my own demise. Well, what happens? So during the initial stages of a lawsuit, you have what they call discovery and disclosure. And you're entitled to information from the plaintiff. The plaintiff's entitled to information from you. But the big piece of discovery in most lawsuits is depositions or EBTs, examination before trial. Deposition or EBT means exactly the same thing. And it's where you're entitled to, the plaintiff's lawyer can take your testimony, not in court. It's sworn. It's within the context of, it's under the jurisdiction of the court, but it's an out-of-court deposition, and their lawyer can question you. You have to answer all the questions. And the same thing, your lawyer can question the party suing you. So let's just say you don't want to, you're not going to participate. You're just not going to show up, or you're going to show up but not answer any questions that can harm you. So you give peripheral information, but you're just not going to answer any questions. You're going to improperly object or whatever. Well, it's not a criminal case, so you're not really in contempt of court. Because there's really no court order per se. These are just discovery rules under the civil laws and practice rules. But what will happen if you don't answer questions or participate in discovery is the plaintiff's attorney will make a motion to court explaining that you're not complying with discovery, you're not giving any testimony, and they're going to ask that your answer be struck. Now, if your answer is struck, they're going to take a default judgment. So that's what could happen. What usually happens is your lawyer will fight it, and your lawyer will say, no, we answered all the questions. These were objectionable, and whatever. Or they were asking for all these documents. It was just vexing. It was overbearing. It was harassment. They're not entitled to it. So your lawyer will duke it out with them. And generally, what generally happens, even when a court finds that a defendant, upon initial finding the defendant was recalcitrant in cooperating with discovery and disclosure, they're not just going to strike the answer. Striking the answer is a very extreme remedy. What they're going to do is issue an order saying, okay, well, I agree with the plaintiff on this, and this. Actually, I agree with the defendant on that. That was a little too much, but defendant, you have to produce the stuff. You got to do it within 45 days or 90 days. You got to answer the rest of these questions. You got to go back and they might even set up, they give an order, interim order, and have a compliance conference. You know what? Come back in 90 days to make sure it's compliance. And you go back, and then if the plaintiff's attorney still feels there was no compliance in what what they were looking for, they can continue to argue it. And again, they're probably not even on the second go around, even if they find they didn't do something right. But what they do, short of striking an answer, is two other things. One is they issue a court order deeming anything that you didn't respond to an omission. So if you refuse to answer whether or not when you run through that light it was red or green, you're not saying I don't know what color it was. You're just saying I'm not answering that question because you damn well know it was red and you screwed up, right? They'll say, okay, purposes of the rest of this litigation is going to be a legal fact that when you went through the light, it was red. So they get deemed whatever you refuse to answer an omission. Or they can just say, you know what, if this gets to jury trial, if this gets to a trial, if it doesn't settle pre-trial, I'm going to let the jury have a negative inference on this point. So I'm going to tell the jury, oh, by the way, you can deem that the light was red when you're deliberating this. You don't have to, but you can. Also, if there's going to be testimony at trial, they can't give any. They would be prohibited from testifying at trial that they had a green light. That was the issue, over a red or green light, because they refused to give that testimony in a deposition. They're not going to allow them to do it for the first time at trial, so they can't deny that they had a red light. They can't really talk about it, and the jury can have a negative inference that in fact the defendant's light was red. So that would be the least punitive remedy. The intermediate one will be deeming whatever you're not going to answer to a fact, and the mother of all punishments for failing to comply with discovery and disclosure is striking your answer. Now, if your answer gets struck, you don't just get the $10 million that your lawyer demanded. You still got to prove your damages. So they'll have what they call an inquest trial. And it could be as easy as putting some receipts in, or it could be as difficult as proving in a personal injury case all the surgeries you had. You might have to still call a doctor as a witness. You're going to have to testify. Then your lawyer is going to have to do a lot of research and find out what similar injuries with a similar person as to your age, your general pedigree, your age, your sex, or whatever, and similar income levels. If you've lost any income, basically do a comp. They run comps on similar accidents on people similar to you in that jurisdiction, in that county, and say, well, Mrs. Jones, who was 67 years old, had the same thing, and they settled her case for $350,000. She had the same knee surgery. Actually, my client has 2 knee surgeries, have bilateral knee surgeries. So my client, should get more than $350,000. So you put your evidence in, and based on your evidence and research as to what similar cases recently went for, your lawyer in a personal injury case is going to argue to the judge. It's called an inquest, as to what your damages should be in this case, and then he'll award you damages. And if it could be a breach of contract, put the contract in, you show what you lost, what you didn't gain, what you lost, whatever, and that's going to be your damages. You still got to prove a valid contract. You still got to prove that you're out of pocket on money if it's over an actual set amount. So that's it. That's what happens when people do not cooperate when they get sued. And I'm bringing this, even though I'm a traffic lawyer, because I think it's really important for all lawyers to have a good fundamental understanding of general areas of the law. I get called all the time from people, prior clients, they don't know who else to call, and something has happened to them legally. And I'm kind of take pride in, one is I don't bite off more than I can chew, but 2 is I know enough about the law to triage anyone's generally common legal case. And make sure they don't make any mistakes early on, because early on you can make a big mistake in civil litigation, and then get them over to the right lawyer. I'll find them a lawyer that specializes in what they need. So that's it for now. Thanks for listening, and I appreciate your comments and your feedback on my videos, and hope to see you again at the next one.